Yes, so good morning. This is the full review hearing for Stack Bar for the Mall Ealing W5 2PJ. Welcome to today's hearing. My name is Councillor Ball and I shall be chairing the hearing. My colleagues, Councillor Baclini, Councillor Nagpal and I comprise today's subcommittee for this full review hearing. Today's hearing follows an expedited review hearing on 27th of September. Oyemi Davis is the legal advisor to the subcommittee. Also present is Sean O'Brien, who is the clerk to the subcommittee and will be minuting the meeting. Isabel Robb, Democratic Services Officer, is also present. In accordance with procedure, I shall invite the police to present the application for a review hearing and call any witnesses in respect of whom permission to appear has been given and answer any questions put to them. I'll then invite the premises to make their representations and answer any questions. And finally, I'll invite the parties to briefly sum up their respective cases. At the end of the hearing, the subcommittee, accompanied by the legal advisor and the committee clerk, will retire to consider its decision. The decision will be given at the end of the meeting and confirmed in writing as soon as possible. So we start with the police presenting their case. So I can see Sergeant Cassar is here.
Yes, Chair. Good morning.
Will you be presenting the police case, or you have representation? Sorry.
We've got representation, Councillor Etwell, Chair. Sorry, apologies. It's the gentleman Aman Soleimani from our Department of Legal Services, sir.
Okay, I can't see you on screen.
Yes, Chair, I'm on screen.
Sorry. Okay, I don't know. I couldn't see you. Good, great. Yes. So, Mr. Soleimani, can you set out the police case, please?
Certainly, and we also have PC Hewison for the police here today, just to introduce her too. Chair, the police are seeking the revocation of this license. We've brought this application because the premises license holder, and at the time the DPS, is alleged to have inflicted grievous bodily harm on two of his patrons, to have inflicted serious violence on two of his patrons, and failed to call the emergency services afterwards. This unacceptable behavior has completely broken the trust of the police. We do not think this is someone who can be entrusted with the significant responsibility of running a late night licensed venue. The police have carefully considered proportionality, and of course I'll come to this, and have determined that the minimum necessary step to uphold the licensing objectives and ensure public safety is revocation. And there are really three reasons for this. The first is that the PLH showed a complete disregard for the licensing objectives, for the responsibilities of his office, for the safety of his customers, when he assaulted two of them and then failed to call the emergency services. He cannot be trusted as a PLH. The second reason is that, as a matter of proportionality, this is the minimum necessary step that can be taken to address this issue of trust. Other steps that are available to you under this legislation, like changing the conditions, simply won't do, because we would still have, at the heart of this license, an untrustworthy PLH. And finally, in addition, the premises has a long history of association with serious reported crimes, and as well as with nuisance, which the environmental health representations attest to. So I'll begin with the first reason, the severity of the trigger incident and how that's broken our trust in the PLH. Now, you've read our application, we've done the last hearing, and you've seen the CCTV, so you know what happens. I won't go into any great detail about it. Suffice to say, there was an altercation with two customers. PLH ejected him. As you know, there was he struck two of them, both with one punch. Well, one punched each of them, knocked them both unconscious to the ground. At that point, he went back into his bar. He left via the back entrance, didn't check on their well-being, and left them on the street in the cold with clearly what may have been serious head injuries. And you've seen the CCTV, so you'll have made your own assessments on the reasonability of that force. We, of course, say that the force used wasn't justified. We certainly say with the second individual who's trying to hold his friend back, the force wasn't justified. And of course, there's absolutely no excuse for the failure to call emergency services. And then that really is the point, Chair. We're here faced with the premises license holder who has behaved utterly unacceptably. he's inflicted serious and unjustified violence on 2 of his customers, or at least 1 of them. And he behaved recklessly and negligently in failing to call the police or an ambulance to deal with the consequences of his violence. Now, at the last hearing, we heard a great deal from the operator, and we've seen a great deal in the operator's submissions about how that force was reasonable, how he thought it was justified. But there were 2 questions they really didn't address at the last hearing, we think still haven't been properly addressed, and really are the 2 central questions on this issue. Firstly, how could it have been reasonable to knock out the second man who was just trying to calm down his friend? And secondly, why did he just leave 2 men unconscious on the pavement at 1 a.m. in the morning when no one was around, in the cold, without calling police or an ambulance, just leaving them to their serious head injuries that could have resulted in something very grave and potentially fatality? Now, the reality was at the last hearing, the PLH had absolutely no explanation, or no real explanation for these questions. With regards to why he assaulted the second man, now, as I recall, this wasn't advanced at the last hearing, but it's now said in these statements that have been prepared after that hearing that he thought the second man had a concealed weapon. The second man was holding a jacket or something to that effect, and he thought that was a weapon, and that's why he had to use reasonable force to knock out the second man. Now, there's 2 points I'd make about that. Firstly, as I recall, nothing was said about that at the last hearing. If that was true, I don't see why that simply wasn't just brought up. Surely that would have been a clear explanation. Not sure why they didn't make that case if it was correct. And secondly, you've seen the CCTV counselors. You know that the second man was trying to calm down his friend. You know the second man was trying to de-escalate the situation. The idea that he was de-escalating and yet at the same time the PLH looked at him and thought he was concealing a weapon and trying to attack him, it's ridiculous. It's not consistent with the CCTV we've seen. So we don't really accept that account. So we don't think the violence against the second man was at all justified. It wasn't a moment of madness. It wasn't justified force. He simply decided to punch someone in the head with sufficient force to knock them out cold. And the next problem, committee, and we didn't get an explanation at the last hearing, and I still haven't seen an explanation now, as to the crucial question, which is why he didn't call emergency services. There's no explanation whatsoever, and that is, in a sense, the most shocking part of this whole sorry incident. Being a premises license holder, being a DPS is a very important job, 2 important jobs. They come with a lot of responsibilities, because when you're running a licensed premises, your job is not just to ensure people have a good time, it's to ensure people are safe, because people are vulnerable in licensed premises. They get drunk, there are risks of conflict, there are also risks of various illnesses, there are risks of things like drink spiking. There are a lot of risks that can pose serious danger to your customers. And to be a PLH, you need to be someone who takes those risks seriously, who takes customer safety seriously, who takes basic human decency seriously. And the fact is, he has not explained at all why he thought it was acceptable to leave 2 people with potentially serious head injuries on the street. The fact is, that behavior was completely inconsistent with what a PLH, as a basic minimum, the kind of character a PLH needs to have. Ultimately, on that basis, we've lost faith in this individual as a license holder. We do not trust them to manage their venue properly. We do not trust them to take care of their customers properly. We do not trust them to manage the significant risks that come with running a late night bar. His continuing management of this premises poses a real risk to the customers of the Stack Bar and to neighboring residents, and that is unacceptable. It poses an unacceptable risk to the licensing objective of public safety. For that reason, we cannot accept him continuing to be a PLH. Now, that brings us on to a second issue, which is proportionality. Now, what the operator says is this was 1 incident, and so it's disproportionate to revoke the license on the basis of 1 incident. I mean, we'd say 2 things about that. 1, it's a very serious incident. It's perfectly legitimate and perfectly common for a committee to revoke a license on the basis of 1 very serious incident. Say the unjustified extreme force used here and the failure to call emergency services is a very, very serious incident itself. But I've already explained that. The problem is this, though. This committee's power is essentially, the reality is we've lost trust in this PLH as the person to run this premises. We think him continuing to be the PLH poses a serious risk to the licensing objectives of public safety. The only way we can control that is by revoking the license, because we've already removed them as DPS, but we can't, this committee doesn't have any powers under the statute to remove a PLH. Now, the reason for that we'd submit is simple. The PLH, the person who's identified as the PLH, is at the core of what the license is. When a committee grants a license in the first place, part of the reason they're granting that license is they're affirming that this individual who's put themselves forward as the PLH is the responsible person who can handle the responsibilities of running a late night licensed venue. The reality is, if we lose trust in that PLH, the license as a whole can't really function. The fact is, the person whose job is to monitor compliance with the licensing objectives, to make sure that the venue is staying within its license, is someone who has proven themselves to be reckless and to have a dangerous attitude towards the licensing objectives. Revocation, therefore, is the only real option here. Imposing conditions wouldn't help, because the reality is we don't trust them to comply with those conditions. We can't force him by condition to take care of his customers. We can't force him by condition to understand that he needs to call emergency services when there are serious injuries on or around his premises after he assaults people. And we'd say it's really telling. You can see from the written submissions of the operator, they've said the steps you should take, in fact, are just to continue to change conditions you put in at the last hearing and add whatever conditions you like, and potentially just give them a formal written warning to make sure he knows they should call emergency services if he's injured outside his premises. Obviously, that doesn't go far enough, committee. Obviously, that doesn't mitigate the risk. We have someone who's behaved in an atrocious way, who has shown complete disregard for public safety in the role of a PLH. Modifying the conditions won't address that. We need revocation of the license, because that's the only way we can control the risk he poses to his customers. In terms of the third reason, there is a history of crime and nuisance associated with this property, with this operator and his operation. Now, to be fair and even-handed, what the police have done is presented essentially every reported crime and issue that's been associated with the premises, and you'll see the police have been clear. Where their offences, where they've investigated and they've identified that's not the PLH's fault, or it's not the premises' fault, they've made that clear in their written submissions. But there are a number of issues, there are a number of instances that speak to a relevant criminal history here. We have the incident on 20th of September 2020, which is paragraph 12 in the police's submissions. A man was assaulted by two males in the bar. He was punched 3 to 4 times, as he reported, and security did nothing about it. The operator simply just says this didn't happen. It didn't happen. And he says the fact that the person asked for tissues proves it didn't happen, because you wouldn't need to ask for tissues, they're on the countertop. I mean, there's quite a bizarre explanation for this, but that's a serious reported crime. 4th of July, which is on 2021, which is paragraph 14 of the police's written submissions. A large group were fighting outside the bar, and the PLH had to be advised not to let customers get too drunk. Now, what the PLH says is that they weren't intoxicated when they were on the premises. That's what he says in his written statement. But it's very hard to understand how these individuals all left the premises at closing time, got into a drunken fight outside the premises, and somehow weren't drunk when they were inside the premises moments before. That didn't make sense to me. On the 14th of November 2021, paragraph 15 of the police's submissions, 2 women reported being racially abused by a security guard who subjected them to lewd comments. A bartender, instead of helping, asked them to go back to his house. It's unacceptable behavior from multiple members of staff and reflects poor management and a lack of care from this premises. 10th of April 2023, which is paragraph 23 of the police's submissions, it was reported to police that every weekend there are fights and violence around the bar. There are things like assaults with sticks, smashing of property, loud shouting, which scares the residents. Now, that's important because it tallies with the reports given by the environmental health team, and it corroborates those reports, so adds weight to them. 27th of July 2024, which is paragraph 27 in the police's submissions, a customer left their phone in the bar. They then went to search for the phone using the phone tracker. They were called and told that they had to pay money to get the phone back. It was being ransomed. They called the phone itself, and they could hear it ringing inside the bar with people laughing. An investigation wasn't taken further, but of course, people being in the bar after closing time, being involved with this criminality in the bar wouldn't happen without the premises knowing about it. The On the 9th of August 2024, which is paragraph 28, the landlord of the premises had tried to remove the premises license holder from the property, and he reported the PLH as trying to break down the door to get back in. He was described as a threatening and crazy person, and the landlord explained the PLH had previously threatened to beat him up. So there is this history of aggressive behavior, of threatening behavior, which tallies with what we've seen here. And finally, 18th of August 2024, paragraph 30, the eviction notices from the landlord were reported as being repeatedly removed. And that's very much reminiscent of the removal of the blue licensing notices, which we mentioned at the last hearing. So, Chair, those are the most relevant, or the particularly relevant crimes outlined by the police. Police have been even-handed in identifying the ones that aren't relevant or the ones that haven't had significant further action taken. The environmental health representation makes similar points. I'm not going to make their submissions for them, but their written submissions are detailed and clear, and they report years of nuisance reports from a large number of locals. Reports of fighting, reports of beating of customers by staff, reports of repeated breaches of the license. There were at least 4 license breaches actively witnessed by environmental health officers, according to those submissions. Now, that makes clear that this premises does have a record of failing to comply with its license conditions, does have a record of playing it fast and loose with the license and not respecting the licensing regime. So, Chair, that establishes there is a history of problems with this venue. It's not just this one incident. So, in conclusion, committee, it's clear that things have gone seriously wrong. The premises license holder has visited very serious violence upon 2 of his customers and those unjustified license. He left them on the street without offering first aid, without calling emergency services. Revocation is the only option here because there's no other option available to you that could control this problem, that could control the problem of having a PLH who is a loose cannon, who doesn't take his customer safety seriously, who lacks the basic human decency to call the emergency services when 2 of his customers are laying flat out unconscious with potential head injuries. It's simply unforgivable. It's broken the trust of the police. We do not see this as a PLH who can be put in charge of a risky premises, that being a late night bar. And the applicant, the operator in their submissions, I'm sure, in the written submissions they have, will try to focus on the question of reasonable force and say these customers were unruly and the force is entirely reasonable. I mean, the 2 things we would say about that is, firstly, it wasn't reasonable, certainly, obviously, with regards to the second man who's trying to calm his friend down. But especially, and the key question remaining, is why he didn't call an ambulance and why he didn't call emergency services. If there's one thing you take from these submissions, it is that failure. It was not a moment of madness. It was not a snap decision. It was a continuing choice to leave 2 men seriously injured on the street because he simply didn't care. And it was a continuing decision and not a snap decision. It was a decision he made when he walked back into his bar and closed the shutters, when he left by the back entrance with his friends so he wouldn't have to step over the bodies of these unconscious men. It was a decision he made when he went home and went to bed without calling anyone. He just didn't care. He didn't care about these seriously injured people, and he was happy to leave them to whatever fate would befall them. The reality is, committee, is that if this application is not granted, if this license is not revoked, and this individual is left as the premises license holder, you will be handing back the keys to a late night bar to a man who doesn't bother to call for help when his customers are seriously injured in that way, who will not take care of customer safety, who has proven himself extremely reckless with the safety of his customers and their well-being. You will be giving that person your stamp of approval as a responsible and safe operator, despite the fact he has still failed to provide any justification whatsoever for failing to call the emergency services. That would be unacceptable. And that is why the police have come to the reluctant conclusion that revocation is the only option. And the committee, of course, understands that risk. That's why you barred him from the premises as a temporary measure, as an interim step. But obviously, that isn't the permanent solution. The permanent solution here is revocation. So for those reasons, we would ask for revocation of the license, and we'd ask that you exercise your powers to continue the interim steps under Section 53D until any appeals process is concluded. So that concludes our primary submissions. Thank you, Chair.
Thank you, Mr. Soleimani. Do you wish to call any witnesses?
Unless the attending officers have anything to say, I'm happy for them to do so. But it doesn't seem that they, yeah.
Okay, so yeah, I'd like to invite questions first from Mr. Dowding, who is representing the premises. Do you have questions for Mr. Soleimani?
No questions, Councillor, thank you.
Okay, thank you. Does Mimi Stupu, do you have any questions?
No, I don't have any questions, thank you.
Okay, so panel members, do you have questions for Mr. Soleimani? Yeah, I see Councillor Baclini.
Thank you, Chair. Mr. Soleimani, in the police submissions, you have provided the committee with a list of incidences dating back to 2020, if I'm right. My question is, pardon?
I was just agreeing with you, Councillor. Apologies.
Yeah. So my question is, why didn't you apply for a review of the license before today? Why all this information is suddenly surfacing? Thank you.
Thank you, Councillor. It may be that's an operational question for the officers, but what I would say is that ordinarily when police make decisions about reviews, because they are very keen to keep things proportionate, because they're very keen not to shut down businesses without full justification, or not to bring reviews without full justification, they do often wait until a trigger incident arises or until there's a sufficient weight of criminality or concern to bring an application for a review. It may be just that over time it wasn't considered that that was enough for a review yet. After this serious incident occurred, it was obviously very clear that something was going seriously wrong at the premises. And at that point, you reflect on all that's come before, you reflect on the incidents that come before and establish what the history of this premises is and how it's being operated. So I think that's probably the basis of the decision. But if the officers have a further explanation, of course, they can provide it.
Okay, any further questions, Councillor Baclini?
No further questions. Thank you, Chair.
And Councillor Nagpal, did you have a question? Okay, I'd just like to ask a question. Yeah, Mr. Soleimani, while I hear what you say about broader management issues, if the PLH is no longer involved in the day-to-day running of the business, is there a risk of incidents similar to the most serious one occurring?
Well, I suppose I would say two things about that, Chair. Firstly, it is difficult to envision how the PLH could not be involved with the day-to-day running of the business. I mean, he is the PLH. Someone needs to be the PLH and have that responsibility to oversee the business and make sure that things are being kept within the licensing objectives. I think that is why the legislation doesn't give you the power to just remove or change a PLH, because someone has to do that job. So I don't see that as reasonable. Even if there was some way to say he's not involved, we ban him from being involved in management, and we just don't have a PLH in reality, and that's a problem too. And yes, I think to be honest, that is a complete answer, Chair. I don't think there is a way for us to just remove him from day-to-day operation. And you are correct that our concern is his role overseeing this premises. We don't think he's a good influence on the premises, but we also don't trust him to keep the premises in the licensing objectives.
Okay, thank you. Yeah, so we have Mimi Stupu from the council's noise and nuisance. Do you want to make a representation at this point?
Yes, thank you, Chair. Sorry, just trying to find my information. Okay. As Mr. Soleimani stated earlier, that the police have lost faith in the premises license holder running this place. Unfortunately, the noise and nuisance team had the same experience over the years. I don't know if the committee is aware, we have been to a number of hearings that involves premises license, extension of premises license, and also temporary event notices hearings. And I would also like to remind the committee that the noise and nuisance team have served 2 abatement notices for loud music and raised voices It was back in 2022, on 3rd of August 2022. Unfortunately, despite the premises license holder being aware, and I served these personally, I've met that premises license holder on site, and I handed these personally, we still received complaints. I appreciate what Mr. Dowding said in his statement, that the complaints are historic. I must emphasize that complaints that exactly 2 years old, or is, well, 2 years and 1 day old, or even with a similar time frame, cannot be classified as historic. The disturbances we reported during this period remain highly relevant, as they directly pertain to ongoing issues caused by the same individual operating the premises. Although the venue has undergone a name change, as we know previously was called Cavalieri, now it's called a Stack, the management and ownership have remained consistent, and this demonstrated a pattern of behaviour that continues to impact the local community. The recurrence of complaints over the period, over this extended period, indicates that the issues are not isolated, but they are rather reflective of a public nuisance. I appreciate that some of the information I have provided in my representation is not necessarily just public nuisance, is also crime and disorder, but I wanted to show the committee that the complaints that we have received and the petition we have received from the residents, the Google reviews, it ties in with the representation from the police and the information that was on the police system. I would like to, I don't know if the committee had the opportunity to read all the noise complaints, but I would like to remind the committee of the last attendance, which was on the 22nd of October 2022, just after midnight. We received a call from a resident. The officer called the complainant back. They stated there's excessive loud music coming from Cavalieri. The complainant said that the loud music has been happening every weekend between 12 p.m. and 2 a.m. The resident stated there is also fights outside the bar every time. The complainant stated the music is excessively loud and would be clearly heard from 100 meters away down the street. Officers agreed to attend. They arrived at the location at 0038. They monitored the noise from Windsor Road opposite Cavalieri. They could hear continuous bass coming from Cavalieri. Despite the noise of the passing traffic, the bass was clearly audible from Windsor Road, approximately 40 to 50 meters away from Cavalieri. Officers considered the bass to be excessive and noted that it would result in significant disturbance to the complainant and other surrounding residential occupiers. And as I said in my representation, that was one complaint, and the officers confirmed that a large number of residents would have been affected. Some residents on that road, they have the bedrooms facing or towards Cavalieri or the Stack. And unfortunately, only one resident called us. From a large number of residents nearby, only one resident called. And as I stated in my representation, most of them are scared because they have seen a large number of physical fights involving the owner, and they just don't want to report and get in trouble. They would rather move away. Sorry, I'm just going through my representation as well. For example, sorry, just give me 1 second if you don't mind.
That's fine.
I wanted to find a particular visit that I carried out to the area. For example, on the 24th of March, 2023, following a request from a resident, I attended the area and I spoke with a large number of residents. Again, Mr. Dowding said that these are historic. A year ago, these are not considered. You can't consider complaints that are 1 year old, they're historic. And these issues have been raised by residents and businesses. You can appreciate, I cannot name the businesses, as I said, they don't want to get involved. And they've raised issues about antisocial behaviour, loud music, raised voices, screaming, fighting outside the premises. I have seen videos of fights. Unfortunately, the residents are not willing. They still reside in the area and they're not willing to provide them. But I have seen them. Yeah, and I made reference in my representation of one of the fights, and there are multiple other videos. I have seen a large number of videos, but as they're recording them from their property, it would be very easy to understand their exact, well, to figure out their address. And also the residents and businesses made reference to incidents where they witnessed their SIA staff making inappropriate comments to heavily intoxicated female customers. Again, it ties in with what the police said and what's on the police system when it comes to women's safety and customer safety, especially women. This was witnessed by residents and businesses. They have no reason to make stuff up. And also, I want to make the committee aware that the businesses I spoke with they can't be considered competition or anything like that. As you know, there isn't a bar nearby that could use this against them. They're not running a premises of similar nature as the Stack. I think that's all from me. It's just I hope the committee has read my presentation, because I don't want to go through everything, but I also would like to remind the committee about the following licensing breaches that we've witnessed. We have witnessed 4 licensing breaches over this period, and the applicant, apologies, the premises license holder was aware of these issues. And I'd like to clarify what Mr. Apologies. I would like to clarify what Councillor Bocklini asked earlier about the police, why they haven't reviewed. So Sergeant Kassar and PC Hewison haven't been involved or haven't worked on this or been involved with this premises as long as I have. There were different police officers, and the previous apologies, I'm just trying to find the information. Apologies, I can't remember the sergeant's name, but that time Cavalieri had numerous visits from the police, and I'm sure the premises license holder would be able to confirm that, as he received warnings, and he had the CCTV reviewed, and also our council's licensing team have attended on a number of occasions further to these incidents that have been reported. So it's not that this is the first time. And also the evidence that I have provided today, I have also used previously in licensing hearings whenever the premises license holder wanted to extend his hours or wanted to apply for a temporary event notice, and I have objected to that. Unfortunately, my evidence wasn't considered, and the hours were still extended. But I raised the same concerns again by the residents, and it seems that the residents were lying from what they were saying, with all this antisocial behaviour linked to the owner, as the police system and the recent incident matches to what the residents have said. And given the council's continuing involvement with the premises, where are the view the operation of the venue is likely to result in a significant public nuisance. I appreciate that sometimes we haven't had complaints every few months, sometimes every 4 or 6 months we haven't received any complaints, but there seems to be a pattern when the police get involved or the licensing team get involved, and then it goes quiet, and then it starts again. And this is exactly what our experience has been with this premises. It goes quiet for a few months, then it starts again, like this incident. Therefore, we support the Metropolitan Police application to review the premises license and also to revoke the premises license. Thank you.
Thank you, Ms. Tupu. So, Mr. Dowding, do you have any questions for Ms. Tupu?
Yes, please. Just 2 very short ones, if I may. Oh, sorry, Ms. Stupu, I think you've hi there.
Yeah.
So the first question is it might be just a matter of semantics, but you've said that 2 years ago can't be considered historic. Can I just ask whether you would adopt the word outdated rather than historic? Because that's the word you've used in your statement.
I have used, because the reason why I have used outdated, because I was aware that the premises license holder will say that they are old complaints, and that was, if you remember my phrase, that I said that they might be considered by some to be outdated, and this is exactly why. But how can they be considered outdated when it's the same person running the place? It's exactly the same person. The management hasn't changed. We served 2 abatement notices. The situation hasn't changed. How can these be considered outdated or historic when the same people, if they were 5-10 years ago, I appreciate that they could be considered historic or outdated. But I did say that some will consider these outdated, but I don't consider them outdated when the same person has been in charge. And it's been on and off if you want to use this, I can use this term, when it comes to complaints.
Right. Well, but perhaps sorry, did you want?
No,
sorry,
that's all. Thank you. No.
The second question I have is about the visits. You mentioned that the last attendance was in 2022. Can I just confirm that the last attendances by yourself were actually 28th and 29th of September 2024?
So the last attendance was on the 14th of May 2023.
So we've got within the police bundle emails from yourself.
Oh, sorry,
to the police
2024.
team.
Yes. Sorry, yeah.
And I just want to read those out for the panel, and you can confirm if that reflects what actually happened at the premises. So you attended on 2 occasions.
I didn't
First
attend.
Was 28th.
I didn't attend.
Oh, sorry, it says officers attended. So this is a report to you by fellow officers,
Correct.
presumably.
Correct, yes.
The first one says 28th of September, officers arrived, 3 door supervisors. Officers could see 2 men approaching, presenting their ID for entry. They were turned away by the security. It looked like they were turned away due to wearing trainers. The door supervisors were pointing at the trainers and speaking to them. And then this, there was no audible music heard from Windsor Road. There were no customers stood outside at the front of the premises. Can I just confirm that is the first report from 28th of September?
From the 20th, yes. Sorry.
On the 29th of September this year, officers attended again and reported to you, which you relayed to the police as follows. Officers arrived at 11:50. They parked SUB on Windsor Road. There was no music audible from Windsor Road. Officers could see 2 door supervisors at the door. Officers saw a woman approach. Her ID was checked before she was allowed to enter. There were no customers loitering outside of the front of the premises, and no one was smoking or drinking outside at the front. Officers departed the location at midnight with all in order. Can I just check that that is the report from 29th of September this year?
Yes.
No further questions, thank you.
Okay, thanks. Do we have any questions from my fellow panel members? Councillor McPhail.
Just a quick one, Ms. Stupu. In your evidence, you've made reference to a petition where 12 residents have signed a petition complaining against the PLH. I don't know if I've missed it, but I didn't see it in the pack. I just wanted to clarify if those were in addition to residents you've spoken to in person, or if they're the same people. Thank you.
They're somewhat different people. I do have the petition. I didn't put it in the representation. This is the second petition. The one I submitted, it was the second petition I was sent. But when this premise was brought to our attention, it was from that petition. And I can't recall, but I can look on the system if you want. I can check within a few minutes by the end of this hearing. From what I recall, I wasn't able to redact it and I didn't use it. But there are some are different residents, but the majority of them are the same at that time. Most of them moved out, to be fair, because of the noise issues. That's what I was informed by one of the residents. They have requested me to go again on site, but some of it before this hearing, they wanted for me to speak on their behalf. Unfortunately, they weren't available, and then they just said if I can reiterate the same concerns, but I haven't been able to speak with them in person on this occasion.
Thank you.
Thank you.
Councillor Baclini, did you have? Yes, you do. Yes. Go ahead.
Thank you, Chair. Ms. Stuper, in your presentation, in the written presentation, you stated somewhere in, I can't really find it now, but you stated that you did door knocking after one resident had complained of the noise.
There is a one main resident that I've been in touch, they said, for 4 years now, and tends to speak on behalf of everyone else. And they're all raising, the other residents were raising a lot of issues to him, and the neighbours were talking. And the person did explain that they have been in touch with me, and they wanted to meet me in person. At that time, I actually suggested the police officer that was dealing with this case, I did suggest to him to join me on that visit. Unfortunately, they were not available, but I have passed that information, and well, I passed more information to them, including names and name of businesses that provided that evidence. As you can appreciate, I had to redact quite a bit on when I used it for my representation. But yes, it was on 24th of March 2023.
Thank you.
I spoke with 8, sorry, I found the bit in my representation, occupants of 8 residential properties.
Yeah.
And so, all 8 were concerned about these
Yes.
issues.
Yeah, but there were more than 8 because, as you can appreciate, some had their families, there were couples. I spoke with some couples, so 3 people residing. So there were more than 8 people. They're just 8. There were 8 residential and 2 businesses.
Thank you. Right, so there's no more questions. We now move on to the Mr. Dowding, please, to present the case for the premises.
Thank you very much, Chair. Well, this is the final hearing in relation to the premises licence review, and you will need to determine what steps are appropriate and proportionate, if any additional steps, to those that have already been taken in relation to the premises. We would respectfully suggest that the approach taken by the police, or the suggestion that revocation is the only option here, is quite a surprising one in light of the new material that's been provided, in particular in relation to the incident on the 19th of September. And in fact, we will be inviting you to make exactly the opposite decision, that revocation in this case would be wholly unjustified on the evidence and wholly disproportionate. You're concerned here with the premises. It needs to be said at the outset, and I make these submissions in direct response to Mr. Solomani's, not individual members of staff alone. You've already taken decisive action in relation to the DPS. He's been removed, and a new highly qualified DPS has been installed. I note that the licensing subcommittee has already approved that decision. It was approved very rapidly. No concerns were raised about her. And I'm afraid I have to say at the outset that Mr. Solomani is, with respect, simply wrong about PLHs and DPSs and the difference between them. It is a basic principle of licensing law that it's the DPS and not the PLH who is responsible for managing the premises and ensuring that it complies with its licensing conditions. A personal license attaches, as the name suggests, and as I'm sure you know, to a person, not a premises. It follows that person around, and any person can apply for a personal license and then serve alcohol at any venue around the country. That's all it allows you to do, is effectively to, it authorises you to engage in the service of alcohol at a licensed premises. The DPS has a much more important role in relation to the premises, as I've already said, which is the management of that premises and its abidance by licensing laws, including the overriding 4 licensing objectives. And so it is that person who is the principal person for the purpose of overseeing licensable activities. Now, it's worth noting also at the outset, just as a preliminary point, that despite the references to the history of the premises, this is the first time that this premises has come to your attention. And that begs the question, one which I was going to address, but it was addressed before I got there by Councillor Baclani, of why, if previous incidents which are referenced within the police evidence, which are referenced within the evidence provided by Ms. Stupu, why, if they were so serious as to warrant a review collectively or individually, why no review was undertaken? If anything in the incidents was sufficiently serious, why were no steps short of a review taken? The only times when steps short of a review have actually been taken were the statutory noise notices. And as I'll come on to, those matters resulted in additional compliance measures being taken by the premises. It installed at considerable expense to itself additional noise stifling measures at the premises. As I say, I'll come back to that shortly. In reference to police attending the premises on numerous occasions, one thing that you will have to do, councillors, and again, this is something I'll come back to as a topic of its own, is distinguish between actual incidents occurring at the premises which relate to the premises and the licensing objectives, such as the 19th of September, and incidents where the police have attended to investigate another offence. It is not uncommon at all, and you will know this dealing with these sorts of cases regularly, for police to attend a premises to obtain CCTV or to speak with staff and ask whether they've seen or heard anything relating to an incident. And there are many examples of that, both within the papers and elsewhere. They show a premises, a licensed premises, operating exactly as it should. On no occasion, for example, have the police pointed to an incident where the premises has refused to cooperate with an investigation or has obstructed an investigation. In fact, quite the contrary. Even in relation to the most serious matter on the 19th of September, as soon as he was spoken to, Mr. Pajerge provided the CCTV. He's since provided a prepared statement. Indeed, he was deemed to be such a low risk in terms of failing to attend that the police allowed him to go on holiday, to leave the country, and to come back and attend a voluntary police interview of his own volition, rather than arresting him and so forth. So these are examples of the premises and its owner cooperating actively with the police, something they've always done and something they would wish to continue doing. Can I just check before I move on to my submissions that you've had a copy of both? I'm assuming this is what you were reading this morning, and I do apologise for the lateness of it, but both the written submissions, the 17-page document, and the respondents bundle, which I think is 59 pages, it has various. Thank you very much.
You've had all that, yes, thank you.
Thank you. Well, with that in mind, there are 5 points I'd make on behalf of the premise, and the first is the development of the investigation relating to the 19th of September. I emphasise at the outset, as I did at the initial hearing, that this is not a criminal trial, and so the extent of sort of engaging with legal principles is much more limited here. But it has been suggested by Mr. Soleimani that no explanation has been provided in relation to a number of aspects of that incident. And I'd respectfully suggest that again, is simply wrong. You will remember that a detailed explanation was provided. Indeed, it was us who suggested showing the CCTV at the last hearing in order to provide you with the evidence and with an explanation on behalf of Mr. Pajerge for his actions that night. We've now provided a much more detailed explanation in the form of his prepared statement in interview with the police, statements from Irvine Jacobs, the DJ, and Mirel Mackay, the friend who was present on that night, all of which paint a much clearer picture of what actually occurred. For example, by indicating or highlighting the things that you can't get from the CCTV, such as the audio, what was being said by the men, how were they behaving, how was that perceived by others. And I'd make the following points in relation to that new material. Firstly, in the witness statements of Mirel Mackay and Irvine Jacobs, which are at pages 40 to 42 of the premises bundle, you can see just how difficult the situation was and just how aggressive the men were being. For example, I think it's Mr. Jacobs who says that the language used was as follows by the bald male. "We're not fucking leaving. We will leave when we want. I'd fucking kill you. Come outside. I'll fucking lay you out." That is a high level of aggression being dealt with, and you will have seen from the CCTV that the way in which Mr. Pajerge handles that within the premises is with absolute calm. He repeatedly attempts to de-escalate the situation and continues to do so when they get outside. As I say, and you'll recall from the CCTV, no doubt, the only point at which force is used is when the bald male rushes towards him. So there can be no doubt in my respectful submission that the two males were the aggressors on that night, that in getting them to leave the premises, Mr. Pajerge and his staff were doing precisely what was required of them by paragraph 17 of their licence. And the question of the extent to which that force being reasonable is concerned, well, that will be a matter for a different person in due course, either the police or a court if it gets that far. The next point I'd make is that while Mr. Bajorge has assisted the investigation by providing names of witnesses, CCTV footage, a full account, the main assailant, the bald male, we now know from the crime report relating to that incident, has refused to provide a statement to the police. Now, of course, we can't speculate too much about the reasons why that might be. We don't know. But you might think it's notable that an apparent victim of crime, someone who the police in this case, a different policing team, the licensing team, say is a victim of a serious crime, why he would not want to substantiate that account. One potential explanation is that he knows full well that he was the aggressor in that scenario. Now, while the male with the jacket on his arm has indicated that he'll provide a statement, both men have refused to provide their clothing for forensic analysis. Again, why? It is in stark contrast, you may think, to the assistance provided to the police by Mr. Bajorge and his colleagues. Fourthly, as I've just alluded to, the police licensing team officers here today are not those who are responsible for the criminal investigation. There have been many references throughout these proceedings to GBH, grievous bodily harm, a much more serious form of criminal activity, but you will see at page 34 of our bundle that Mr. Bajorge, as the investigation has developed, things have changed and he has not been interviewed for grievous bodily harm. He's been interviewed for the much lesser offence of causing actual bodily harm. So it's worth noting, as I say, that as the investigation has developed, other matters have come to light, for example, the nature and extent of the injuries. Fifthly, on the emergency services point, it's simply wrong to say that no explanation has been provided. As I explained on the last occasion, Mr. Bajorge immediately shut the door and went back into the premises, put the shutters down and attempted to assist others within the bar to leave the premises. It is simply common sense that he would not have been aware of the state or condition that those men were in at the time. Now, I did also say at the outset of the hearing on the last occasion that Mr. Bajorge did perhaps regret not having taken further action or not having gone back out there to check on them, and that may be a cross that he has to bear. But a further point that I referenced, that indeed you took into account on that occasion, was the deficiency in the premises licence as it previously existed, because there was no requirement on him to do any of that as the incident occurred outside of the premises. That has now been rectified with a new condition on the licence. But can I just make a final point on that topic, which is that based on Mr. Soleimani's submissions, there appears to be some sort of suggestion that Mr. Bajorge, as a DPS or as a licence holder, has to act as some sort of robot, has to be able to anticipate everything that's coming his way, has to act with perfect instincts in a scenario like that. But this is a man who, as far as we all know, has never been involved in an incident of this nature in his entire life. It was a highly charged incident involving two highly aggressive males, and it appears to have been the first occasion when he has ever had to punch someone. You might think that there would have been a considerable amount of adrenaline pumping through his veins at that point in time, and he is a human being after all. So I just invite you to apply a little bit of common sense when you consider how he was acting after the event, and give him a little bit of allowance when you consider the fact that he might himself have been in a bit of a state of shock at the whole incident. Now, to some extent, in my submission, the incident itself is slightly less important than the new information which I'm now coming on to, because the panel has already removed the DPS. There is already a highly qualified DPS installed. The panel has already amended the licensing conditions in order specifically to deal with the issues that have been identified as part and parcel of the review of that incident. But I wanted to highlight those factors just to show that the initial hypothesis of the police is becoming less compelling over time and as the investigation continues. My second topic then, and this is where we come on to the new material, and the headline for this topic is my invitation to you to beware of the white noise. In my written submissions, I've highlighted at paragraphs 10 to 11 the statutory guidance that you must apply. And that makes clear that any decision that you take has to be evidence-based and that you must take no steps other than those which are appropriate and proportionate. These are important points of principle which it's necessary to draw to your attention, because although Mr. Soleimani says that all of these incidents have been provided to provide a sort of general picture of, fairness, that we had to provide everything or nothing, it actually appears that there's been something of and again, no criticism is meant. I appreciate these proceedings are all quite rushed because it's a 28-day time limit, but there's been something of an indiscriminate trawl of policing systems, and you've been provided with a voluminous mass of material, much of which, in fact, I would suggest the vast majority of which is irrelevant and should be put out of your minds for various reasons. And I've tried to assist you with that in my written submissions with the table that you've seen, hopefully, anyway, that's within that document. Police systems record and maintain records of everything which is reported, whatever the resolution is and however weak the evidence is. But your role, in accordance with the guidance then, is to try and make sense of what within that morass or mass of material is relevant. Now, can I just take you through a couple of examples? I won't take you through nearly or much of it at all, but just a couple of examples to highlight this point. The first is at, I think it's number, it might be number 20, but let me just find it. Yeah, number 20 on the table. So this is page 11. You don't necessarily have to turn it up. I'll read it out for you and summarize it, but it's for your reference. It's page 11. This is a report by an intoxicated male. It's one of the ones I've highlighted in blue, stating that he had been assaulted at the premises. Now, when describing a lot of these incidents, Mr. Soleimani describes them as fact. He says, a female who was Brazilian says that she was treated in a racist way by members of staff. Again, no police action was taken in relation to that, no further investigation. The alleged victim didn't assist the police in any way, shape or form. This provides an example of why you cannot treat those reports as fact. There was a report of an assault, 5th of May, 2024. Police reviewed the CCTV at the premises. They spoke to staff and they concluded that the male had not been a victim of an assault. And further than this is perhaps the most striking example, he hadn't even entered the premises. So this male who reported to the police have served this evidence. He reported to the police that he'd been a victim of an assault at the premises, hadn't even been in there and was not the victim. All of the examples highlighted in blue are examples of security staff ejecting patrons. And without fail, when the police investigate, after a spurious report is made by that patron saying, oh, I've been assaulted, I've been a victim of crime. When the police investigate, they find that there is no crime and that in fact the person was lawfully ejected. And in most of those instances, the person ejected subsequently accepts that it was lawful. So this is a stark reminder of why crime reports and CAD reports, unless there is a further investigation where you've got witness statements, where you've got compelling evidence that something has actually happened, must be taken not with a pinch, but with a fistful of salt. Other examples, well, I've highlighted 2 examples, in fact, the only 2 I would suggest that are worthy of your attention. The first is number 8 on that table, which is at page 7. This is a report of a group of people fighting outside of the premises. There is no suggestion in relation to this report that any of those people were engaged in a fight inside the premises. There is no suggestion that there was any breach of licensing conditions or any failure on the part of the premises. The sole reason that this is relevant, I say, is that it is an example of the premises being spoken to by the police or being given guidance as to the need to ensure or take care with the level of intoxication on the part of its patrons and listening to that guidance. But some additional contextual information, as the police have included it, is that this occurred after a World Cup football match and just after a period of lockdown during COVID. And when you look at the actual crime reports, which I urge you to do, I've given you the references in the right-hand column, you'll see that those men had not just been in the premises, they had been in a number of other pubs during the course of the rest of that evening. So again, it's an example, I say, of something where you cannot simply point at the premises and say this is a premises doing something wrong. The picture is more complicated than that. And then number 13, this is on page 9. You'll remember it was an allegation of spiking. When you look at the report, you can see very clearly that no medical testing occurred. There was no confirmed spiking. Despite that, the premises didn't push back against engaging with the police. In fact, they did engage with the police. Mr. Bajaj spoke with a police officer, stated clearly that he would ask his staff to be more vigilant, and agreed to put up Ask Angela posters if they were provided. The overall picture, as I've set out at paragraph 17, when you look at all of these various reports, is that this is not a premises which is dysfunctional or incapable of redemption. This is a premises which is operating exactly as it should be operating. There are clear examples of staff taking reasonable action to eject patrons, those same patrons then making police reports spuriously, and the police investigating and finding that the premises acted perfectly lawfully. There are examples of the police engaging with the premises, for example, in relation to the spiking and the premises taking that on board. These are all, as I say, examples of the premises licensed premises acting lawfully and properly. As I've already noted, I just ask you to finally consider on this topic that rhetorical question I mentioned earlier. If any of these matters, which Mr. Soleimani suggested were almost fact when he was reading them out, had caused any real concern about the management of this premises over time, would action not have been taken sooner? Is that seriously being suggested? If any of these incidents of alleged assault or thefts at the premises or things connected to the premises in any way suggested that this was dysfunctional, why on earth was a review not initiated sooner or written warnings given, and so on? Third topic, the noise and nuisance allegations. These are addressed in the written submissions at paragraphs 21 to 28. These issues are, in my respectful submission, historic or outdated, whichever word you would like to adopt. Now, we don't say that they're irrelevant, but they do require some additional explanation, and I'll provide that now. Various points can be made. Firstly, the premises 2 years ago in August 2022 had 2 statutory notices given to it in relation to noise concerns. In my submission, they engaged fully with the local authority and at considerable expense to the business took steps to cooperate. They installed, and you can see this on the CCTV, soundproof double doors, which include one layer, then a soundproof layer, and then another door. They installed a new sound system and a sound limiter to ensure that no music exceeds 83 decibels. And it is notable, you might think, that despite the fact that there have been references to concerns being raised since then, there have been no further statutory notices served on the business which would have required it to comply. There haven't been any further reviews of the premises license or any reviews of the premises license until now. If necessary, Mr. Bajaj can assist further in relation to this matter if anybody has questions for him in due course. But the premises also has a dispersal policy and signs up requiring people to leave quietly. It does take measures in relation to this, and you might think, just coming on directly to the next point, which is a neat segue, that they are successful measures, because when you look at the 2 most recent reports, 28th and 29th of September 2024, no noise emanating from the premises, no concerns raised whatsoever. The next point is that those of you, I'm sure you're much more familiar than I don't live in Ealing myself, but those who are familiar with the local area, and I've done a bit of Googling, I know that Mr. Bajaj himself is, and he's assisted me, will know that the premises is situated on a very busy street, Windsor Road. It's a pedestrianised, in parts it's a pedestrianised area, but it's a thoroughfare for students. There are also other late night venues, including a food venue, I think it's a pizza shop, in addition to a Wetherspoons nearby and 2 other bars within around 100 metres of the premises. There are obviously concerns that have been raised by locals within the area, but that is worth bearing in mind because a lot of those concerns refer to matters occurring outside of Stack Bar, and I just invite you to carefully consider the report that's been served, because matters occurring outside, which may well have originated from other premises, are not within the control of Stack Bar. And then in terms of the reference to video evidence, I'd simply invite you to place no weight on that at all, because it's been impossible for us to challenge it or test it. You haven't seen any video evidence yourselves, and ultimately it would be unfair to the premises to take that into account, because how on earth are we supposed to deal with that, to see what actually occurs, whether it occurs near the premises, outside the premises, in the premises, to question who is present and to quiz or test the footage in question. So that's what I'd say in relation to the video footage. And then finally, on the petition front, as I mentioned at the last hearing, while there's been a reference to a petition, I think signed by 24 people, concerning noise at the premises, you're aware of another petition which was served on behalf of the premises when it successfully applied to extend its operating hours, and that was signed by 500 local people. So worth bearing that in mind when you're considering the balance. You may think overall, and I invite you to find, that while there are some historic issues with sound, the evidence shows pretty clearly that those ongoing concerns relating to sound do not exist, and that the premises has done everything it can to ensure that there is no sound leakage from the property. That final point, again, is a nice segue into the fourth penultimate submission. This can be dealt with more rapidly, which is the overall impression of the premises. Ms. Stupu has provided some Google reviews, which she told you earlier today tie in with what she said about noise complaints. We've provided you, for the purposes of balance, with all of the remaining Google reviews. Now, the overall impression given by the noise and nuisance team and the police, in my respectful submission, is not a balanced one. When you look at the Google reviews, you will see that the total score is 4.4 stars out of 5, a pretty good score overall. But when you look at the detail of them, these are not people just simply clicking, 4 stars, 5 stars. These are people who leave reviews and comment on the premises, and they are effusive with praise. Best place in London, one of the best places in Ealing, a little treasure. Appreciation is expressed for Albert's drink mixing skills. There is praise for the hospitality of the staff and the service at the venue, and indeed the safety of the venue. This presents a very different picture to that which the police and the NNT are seeking to paint of the premises at the hearing. And that picture, the one that I've just identified, is supported by the letters of support which have been provided by 10 other people in support of the premises. Quite a number of people, you may think, given the detail of the letters and the short time within which the premises has had to ask people to commit pen to paper. They are likewise replete with references to the value that the premises brings to the local community. And again, I emphasise the safety of the premises. We have men and women providing these reviews, all of whom comment on the safety that they feel when they are at the premises. It is, in short, a vibrant venue which is beloved by the local community, and it has been described repeatedly as a safe and welcoming place. So finally, what should be done? You have already taken decisive action in a number of ways, and I won't reiterate that. There's no point. You're aware of the action that you've taken in removing the DPS and instructing Mr. Bourgeois that he cannot be involved as an interim measure in the management of the premises. It was suggested by Mr. Soleimani that you would be handing back the keys to a person who is not safe and responsible as an operator were you to do anything other than revoke this licence. But as I've already explained at the outset, and you have my submissions in writing, it is the DPS who is at the helm of managing a business of this nature. The PLH does not have that role. The simple fact that Mr. Bourgeois has or holds a PLH should not be held against him in these circumstances. We have on the call Miss Emma Pryor, who is the new DPS, who was approved by yourselves. She is here and can field any questions which you have about the premises, having worked there herself for a period of time and having an experienced background. She's also provided a witness statement which you've seen. We would say that the measures you have taken are sufficient to ensure that this premises upholds the licensing objectives if you convert those into final measures at the review hearing for a premises that's never previously been subject to a review. However, there are other measures that you can take if you would like to, and the premises would of course abide by those. I've set out some suggestions at paragraphs 29 to 33, namely additional training for members of staff, which the premises has agreed to devise in conjunction with the police and the local authority in order to provide them or assuage any fears on their part that the training would be inadequate. In addition, the possibility of a written warning. Now, the reason I've mentioned this is that within the statutory guidance which you're bound to apply, you'll have seen that I've quoted at paragraph 12 of the written submissions from that guidance. where it says it is expected that licensing authority will regard such warnings as an important mechanism for ensuring that the licensing objectives are effectively promoted, and that warnings should be issued in writing to the license holder. So a warning, particularly when given in addition to other measures, should not be seen as a light touch. It is something that will remain on the record of the license holder, will be brought up, no doubt, again if there is any future review, and ultimately would act as a significant deterrent. So those are the measures that we propose, of course, in addition to any others that you would deem necessary in the circumstances. Unless I can assist further at this stage, those are the representations I'd make.
Yeah, thank you, Mr. Dowding. Do you intend to call any witness?
No, but as I say, we've got Ms. Pryor here and Mr. Pajerge, who are both able to assist me in addressing any questions that you or the police or Ms. Stupu may have.
Okay, so before questions, I just thought, Ms. Davies, I wondered if you might be able to assist the panel in terms of the, we've had differing views from the two parties about the respective roles of the premises license holder and the DPS in terms of management of licensable activities at the venue. Is there anything you would like to advise the panel on in respect of that?
Yes, thank you, Chair. What I would say is this is considering the national guidance and legislation and e-policy. The license holder has a responsibility to uphold the license.
Sorry, Chair, we can't really hear you, Ms. Davis.
Can you just speak up a bit? Yeah, it's a bit faint.
Yes, can you hear me better now?
A little bit quiet.
Hear me better now?
I mean, so just a bit low. I can, if I turn my volume up, I can hear you.
Hear me now?
I've turned my volume up. I ask other people to turn their volume up. It's just purely a bit low, isn't it? But I can hear now. Okay.
Right. Okay. If you can't hear me, I'll speak up. But if you can't hear me, please do let me know. So as I said, just in reference to the national guidance, Ealing policy and legislation, the premises license holder has a responsibility for upholding the licensing objectives. The designated premises supervisor is the person that has the day-to-day responsibility for running the business. I hope that assists.
Yeah, that's helpful. Thank you. Thank you. Great. Good. Right. So
I'll just confirm that was personal. So I think it was just said premises license holder. I think it was that in reference to personal license holder, Ms. Davies, or it might have just been a slip of the tongue.
Thank you, Mr. Dowding. It was a designated premises supervisor.
Sorry, thank you. But the first person you referenced, you said the designated premises supervisor, and then you said the premises license holder. I assume that was in reference to personal license holder. I just want to make sure.
Yes.
Thank you. Thank you very much.
Right.
So,
Okay.
to be clear, Mr. Dowding, what I've said is the premises license holder has a responsibility to uphold the licensing objectives.
Yeah. Thank you.
Thank you. I hope that helps.
Thank you. It does.
Thank you very much, Mr. Davis. Yeah. Thank you. Right. So now I'd like to invite the applicant, Mr. Soleimani, to ask any questions to the premises he wishes to ask.
No questions, Chair. Thank you.
Okay. Mr. Poo, do you want to ask any questions at this point? No.
No, thank you.
No. Okay, great. Right. So panel members. Yes, I see Councillor Bocchini.
Thank you, Chair. I've got a question for Mr. Pajerge. Why did you change the name of your premises? Can we think that it's because of the many incidents that happened?
Good morning, councillors. Good morning, everyone. We rebranded after 5 years, which is a business, is a branding measure, nothing to do with anything relating to the name. We asked our regular customers, we shortlisted a few names, and then we picked a new branding name. That happens in a lot of business. After 5 years, we consulted our marketing manager, and they advised that if you change the branding name, it could potentially be better for the business, but it's nothing to do with anything that you're suggesting. We rebranded after 5 years. There's a lot of brands go through this.
Thank you. Chair, I've got another question. So in the bundle and in the police additional conditions that were agreed back in 2018, Mr. Pajerji, at condition number 30, it clearly states that in the event of a serious assault, you have to, the management, you will have to immediately contact the police or any London ambulance service without delay. So my question was, which is still unanswered from the last time, how did you just close the shutters and not phone the police? If you can just clearly and honestly tell us why this happened.
Can I just pause there just for one moment? So I am happy for Mr. Pajerji to answer that question. I just wonder whether we can go into private session for that, because as I say, this is an investigation that's ongoing on the part of the police.
I am not concerned about the actual whatever incident happened. This question is directly about
the afterward bit.
Upholding the objectives of the license. It has nothing to do with the incident. So please, if Mr. Pajerji could answer this question, I'd be grateful. Thank you.
I wasn't aware of the extent of the injuries at all. I believe these two men still posed a threat to me and to everybody else involved. I had more vulnerable people trapped inside the premises who were actually, they're very vulnerable, and I felt that they needed to be assisted after the aftermath. I wasn't aware of the extent of the injuries caused to these two individuals. I felt obliged that there was a fairly big group of women inside, young women, that they weren't involved at all, but they were trapped inside. So I felt that they needed the attention of myself before anything else. And that's my explanation.
I'd like to follow up on that, actually, Mr. Pajerji. Isn't it? I mean, basically, yeah, you're maintaining that you weren't aware of their condition, but is it not the case that you punched them hard enough for them to end up on the ground? So is it not reasonable that you would expect them to be injured by that?
Not necessarily. I use reasonable force. The two men, I believe they use reasonable force, and then I didn't believe the impact would have had those conclusions. I was made aware next morning through my landlord, and as soon as I was made aware of what's happened, I attended the scene immediately. I told the two officers on site, I told them that I've been involved in this incident. I would like to assist. I haven't been aware, and he said that we've spoken to a landlord, and then and he said we've been trying to get a hold of you. I said, well, I'm here. This is my phone number. They checked the phone number, which was actually the same. No one had called me. There's no contact to the premises, which would have come straight to me through the website, email, or the phone numbers provided. The officer on site, he showed me a phone number they had on their notes, and it actually was my phone number. And no one's actually called me to say what's happened. I believe the landlord could have provided that number at the time he was contacted. As soon as I was made aware, I went straight to the venue. I provided my assistance, and I said to the police officers on site, I said I would like to help. I'm not aware of what's happened. After I've taken everyone out from the fire exit to the back, and I told her I would like to help. A short while after, I was visited at home by the investigating officers from the Acton Police, and I said to them, and I would like to help as much as I can, and that's what happened.
Thank you. So yeah, well, Councillor McLean, did you want to ask anything else, or you? Yeah.
Sorry, Councillor
Yes,
Ball, it's actually a follow on from these questions. That's
Oh,
why
okay.
I thought it
All right.
relevant.
Oh, fine. Yeah. Okay. Yeah.
Thank
If it's
you, Chair.
following on to this same line, then Councillor Nagpal. Yeah. Thanks.
Mr. Pajojo, we've watched the CCTV, and your CCTV system appears to be quite an advanced system. I wanted to ask if you have the ability to view this CCTV remotely from a mobile phone, and if you considered as an afterthought when you got home to perhaps have a look to see what was happening outside the premises, or indeed while you were still in the premises escorting the young ladies out, if there was a screen within which you could see that these two gentlemen were clearly passed out or knocked out rather, and perhaps was it at all an afterthought that perhaps at that point you should call the emergency services? Thank you.
We had a contract with BT, which was the original broadband supplier. I had connection to my device. Unfortunately, about a year ago, we have a different supplier who is a very weak. That address does not provide fiber or any form of a fast internet. It's copper still, which is the same system has been used for the past 20 years. Unfortunately, this internet provider that we have right now, we are contracted with them for the next. It was a 24-month contract. Unfortunately, they do not provide enough data where you can use remotely, or we can view from a different device, except from the original DVR system, which we already have in the premises, and as the police have been able to access it. I did not see or notice anything. There's no connection from my device to the system at this time or at the time, unfortunately.
Okay, so Councillor McLean, do you have a separate question?
Yes, thank you, Chair. Mr. Dowding, in your presentation, you told us about the dispersal policy that clearly well, in the pub you have posters requiring people to leave quietly. Yeah. Now, since the incident, I would like to ask Miss Emma, what is her understanding of dispersal strategy, specifically after this incident had happened? What specific measures have been implemented to ensure the safe and orderly dispersal of patrons, especially in light of the incidents reported?
All the staff are now aware of all the dispersals, which would make sure that they're up to date with all of that stuff. When people leave the premises, we also have the door staff or staff, if it's not a weekend, to ask people to disperse quietly and not to loiter also outside of the premises, so we don't make any noise for the neighbours and obviously other businesses that are running around us. Is that it?
Thank you, Miss Emma. Yes, I'm more concerned about the external area right outside the bar where the incident happened. So in terms of the dispersal strategy that you would be implementing, do you have any new orders that you have implemented to make sure that nothing happens like the incident, the previous incident?
Well, yeah, just to make sure that people do disperse, that we are being careful when we disperse these people. Once again, as I said, we do not allow people to loiter outside the premises, especially after we've closed. We ask them to leave quietly and to not be hanging around our premises outside to cause any obstruction or any kind of delays or anything that we had before.
Councillor Backlani, might I just add something to that as well, which is that in relation, insofar as dispersal is concerned, of course, dispersal being the slow trickling of people out of the premises to avoid any noise occurring within the local area. There is a separate consideration here which has been directly addressed both by yourselves and the premises, which is security, exactly. Yes. And that's the real problem, because, of course, these men, there wasn't necessarily an issue with their dispersal in the first place. It appears that one of them did leave and then came back in. It was really an issue with regard to security at the premises. And now there is a new condition making clear that there has to be an independent security team on premises. Of course, it would be open to yourselves to consider whether additional SIA would be required at the premises, although obviously bearing in mind proportionality of any measures and the cost to the premises of incorporating that. But I just wanted to add that in, that sort of separate consideration.
Yeah, we're very much aware. Thank you, Mr. Dowding. Thank you, Chair.
Thank you. Can I ask Councillor Nopal to ask any questions?
Thank you, Chair. Mr. Dowding, can you please explain to me what you mean by a highly qualified DPS?
Yeah, it's somebody who has, and I can ask Ms. Pryor to come in here, but you've got a copy of her witness statement. And what I mean when I say highly qualified is someone who is appropriate for the role, who is able to take up that role, who's never had any previous issues, who has dealt with the role of DPS and with licensed premises in the past. That's what I mean when I say highly qualified. I'm not suggesting a superstar DPS, or I'm not suggesting a sort of celebrity DPS, but I'm just suggesting she is clearly, manifestly well qualified for that role. Indeed, if there were any concerns, no doubt there would have been an objection to the transfer. It's open to the police to object to transfer, and there were no objections as I understand it. But I can certainly ask Ms. Pryor to outline her experience for you if that would assist.
No, I think that suffices. My second question is to Mr. Pajerge. So Mr. Dowding articulated and the statement articulated the words that were used by the gentleman that you escorted out of the building. So when they were making such threats as I will kill you and I will lay you out, is it not your policy or your staff's policy to, at that point, contact emergency services, the police, because somebody has made a verbal threat to you? And if it is or is not, can you explain why you didn't call the police at that point, or ask your team to call the police?
Well, at the time, we were, me, Irvine, and Mr. Mackay, we tried everything to de-escalate, which was undertaken in my SIA training. So there's a period of about 13 minutes between the first encounter and to the end of the event. I tried to de-escalate. There was no, obviously, there was no reminding in myself that I needed to call the police at that time, to call 999. It is a first encounter of such in the venue. I have to remind you that there's two guys. We're part of a very well-behaved group early on, which they came in, they were respectful. They opened a big tab and they closed it, and it appears that their leader thanked everybody, including myself, and he brought a little round of drinks to the guests in there. And it was a question of, they've been obviously drinking beforehand, and they didn't drink much in the venue that night, but they were well behaved, part of a professional group. It was a bit of a surprise to their behavior. It was everyone was surprised. Myself and the two others that were present, we did try to de-escalate completely from the start. There was no language used from us. There was no any shouting. There was nothing to indicate that we didn't expect these guys. But as their behavior became very aggressive towards the end, it was a case of a split decision making and very, very carefully considering the circumstances. I don't think the police would have saved anybody from what was going to happen, as everything happened pretty much within a minute. I'm talking about the altercation. I could have thought about it, but I honestly speaking, at that moment, I was just caring about my safety and the safety of everybody else present. So these guys, as I said, they were part of a well-behaved group. One of them has entered the premises 3 times after we are closed. He's gone under the shutters. We put the shutters down at the time when the premise is supposed to close, which is a clear indication of the premises is actually closed. He entered with pretexts that he has a girlfriend inside. Now, from my understanding was that there was nobody known to them. So one of them said he had a girlfriend inside, and then and I was confused as to he potentially could have been someone they known before, an ex-partner or ex-girlfriend. And I made sure that obviously that I wasn't interfering with someone's personal relation or they could have had before. So I double-checked everything. So this guy was basically entered the premises 3 times. We warned them. I warned them. I begged with them for several minutes, and unfortunately, at the time, it did not cross my mind to call the police immediately. But as I said, the police probably could have made it there within a minute, even if I had to. It is a moment of immense pressure. Obviously, I was the person that a lot of people were under my care and supervision. Unfortunately, I had to do what I did because the safety of everybody was at stake in those moments.
Okay, thank you.
Sorry, to clarify then, are you aware that it's part of your licensing objectives to call the police when there's an altercation within the premises?
Well, there was two individuals who had posted a threat, and I believe that they still posed a threat. Had I been involved with them, obviously, had I stood outside, as I said, I use reasonable force. I'm not an 8-foot boxer or anything. I'm just a normal person. This is the first that I've been involved with. I believe I used reasonable force, and I did not believe that the police or the ambulance was required at the time. As soon as I found out, I did provide my assistance to the police.
So to clarify, Mr. Pujaje, at the time you thought that it would be better for you to take matters into your own hands rather than call the authorities? Just yes or no, it will suffice.
I did not take matters into my own hands. I acted in self-defense. I believe these 2 men were very visibly, they were the aggressors, unfortunately. They ended up being the aggressors. I was pretty much by myself. And these 2 guys, I believe they had other intentions. As I said, they re-entered the premises. One of them was remained behind. And one of them re-entered the premises 3 times after the premises being closed. So I didn't take the matters into my own hands. I had to react to a situation.
Councillor, might I just add something onto the end of that? It's just to make reference briefly to paragraph 30 of the licence, which was, I think, referred to by Councillor Baklani earlier. The conditions on the licence impose an obligation in the event that a serious assault is committed on the premises to contact the police. Now, obviously, it may well be the view of the licensing subcommittee that it may have been preferable for the DPS to take different actions whilst in the premises, although I would obviously invite you to have in mind the high pressure nature of that scenario and to have a careful look at the CCTV, which, you've got people moving around inside, eventually outside, difficulties with these 2 men. But one thing I would just briefly note is that it is, of course, open to the licensing subcommittee, in addition to any further training, as we have suggested, to amend that condition so that not only is it, as you've already amended it, things happening just outside of the premises, but that it includes something wider than a serious assault, because of course no serious assault had happened at all within the premises or indeed outside of the premises up until that last moment. So I would just invite you or make reference to that condition and the amendments which might be made to it to encapsulate a much wider form of incident. Thank you.
Okay, thanks. So I can see Mr. Booth hand.
Sorry, just one more
sorry.
question.
Oh yeah, okay. You finished. You finished then. Yep.
Sorry, Mr. Pujari, throughout the evidence, there's been lots of reference to people being heavily intoxicated, inebriated, drunk, removed for being drunk. You said so yourself just now. The group opened a tab and bought several drinks. What is your bar's policy on serving alcohol to people who are already intoxicated? And do you maintain a log of refusal to serve drinks? Do you refuse to serve drinks? Can you elaborate on your policy somewhat for me, please?
Absolutely. If someone appears intoxicated, especially on the door or by the bar, it is a venue policy not to serve them. We always check on them. We ask them how many drinks they've had, and if they're in a group of friends, we ask them, are they fit to drink? Or if they appear intoxicated to us or to any member of staff, we absolutely refuse alcohol, and we provide them with a glass of water and ice. When we do, sometimes we have bottled water that we stock. That's for people that we believe they need water to take away. So it's bottled water, which has got a sports cap. That's just to take out of the premises. We do provide people that we believe they've had or they must have been drinking elsewhere, and then the drink they mixed in our bar could have influenced their level of intoxication. We do not serve alcohol to anybody that appears to be intoxicated. And given the reference to this group, they were a well-behaved group. Unfortunately, everybody's left was left without issues, but there's a group of 20 men, approximately 20 men, and then the bald man had remained behind. I have no idea how and why, but the other guy has already left. He already left with a big group. He's decided to hang back behind. No further comment.
Okay, that's the end of your questions, Councillor Nopal. Yeah. Okay, so yeah, I can see Mr. Pooh. We were was your opportunity earlier on, but I'll let you off if you've got something.
Sorry, yeah, if you don't mind. Yeah. I thought of something, if you don't mind. Thank you, Chair. I just want to go back to the incident, and Mr. Pujari was worried about the welfare of the customers inside the bar and hence his decision to punch them. But then he still left the bar through the rear exit door. Why did he feel that those customers were in danger, but then they still decided to leave the bar? Why didn't he do that right from the beginning? Kick them out, put the shutters down and leave through the back? So why did he feel that those customers were in danger, and why didn't he think about that option? He still carried out, he still left the premises via the back. Why didn't he do that right from the beginning instead of punching them? So why were those patrons in danger, and why did you think they were in danger?
Because there's been, sorry, this question directed at me?
Yes, it is, yes.
Yeah, sorry, there was a man referencing that a female, his girlfriend, is inside.
No, I appreciate it. I understood that, but when you were outside, why didn't you just put the shutters in? You've mentioned that you had to protect the people inside, your customers. Why didn't you just put the shutters down and leave through the back? Because you've said earlier that you left through the back of the premises, so you had the option to exit through the back. The customers didn't have to exit through the front.
If you look at the cameras, the shutters were brought down at 1:30 when the premises closed. The shutters were completely down. But if you see from the outside camera, the gentleman wearing white, he's still outside the premises. I don't know what he's waiting for, or what was the reason he's there. So the shutters were down completely. So there was the bald man that was left behind or hiding behind in the toilets, which we noticed when he came out. That's when I opened the shutters for him to leave, even though the shutters were actually open at this moment halfway, or 1/4. So we did open it. The shutters were completely closed. You can see that on CCTV. The shutters closed when we normally close them. When the permitted hours are up, we put the shutters halfway just to indicate the venue is closed. At this moment, on this night, the shutters were completely down at some point. We did raise the shutters open for the bald man to leave, and that's when everything, unfortunately, got more complex. The shutters were down, but as I said, it's our policy that the groups of women do not hang around when there's a man or two outside. They wait for their cabs to leave. We really put it into our statement. So this is what happened this night. The shutters were down twice, unfortunately, but we did open them for one of the men to leave, and we found out that the other man, his friend, was still hanging outside, and this is the man that's entered the premises 3 times when the premises had already been closed.
Okay,
No
thank
further
you.
comment.
Thanks.
Thank you.
Yeah, so I'd just like to ask a couple of questions. So firstly, for Mr. Bajerje, what do you say to the allegations that Mustupu made earlier that residents are experiencing, nearby residents are experiencing regular noise from the premises, and that they're afraid of being identified by showing CCTV and so on because they've witnessed fights outside the premises? They have a low view of the premises. What's your take on that, on those allegations?
So may I ask, when is this allegation made?
Well, I'm paraphrasing, but in Ms. Tupu's comments, she said that she talked about visiting residents, and that a number of them indicated that they were having noise from the residents and local businesses. A number of them were experiencing noise from the premises, and also they talked about witnessing incidents that they were worried about, the situation for women visiting. And then Ms. Tupu was saying that the reason that she had seen some CCTV, but the reason the CCTV wasn't available was because the witness who took that was afraid of revealing
sorry.
evidence. Yeah.
So, Joe, it's not CCTV, they're video recordings that are dated and time-stamped. Yeah, sorry.
Video out of the window kind of thing. Yeah. So I'm just that was the flavour of what Mr. Tupu was saying. I would like to have your reaction to that.
Well, we in our witness statements from the beginning of, since we've been made known to Ealing Council, all our witness statements, they've been provided by people that they know the venue or they witnessed something. This statement references that they're afraid to come forward. Unfortunately, I cannot say or be able to answer something to an unknown person who references that they're afraid. I've got no record of anything in the venue prior, and I believe these statements are from about 2 years ago. There's no, we've had a resident email us one time, and then he said that the noise is emanating from the venue. I've referenced, he said
Sorry.
that
Sorry, Mr. Bajerje. Miss Emma, can you put your screen on mute, please? Because we're hearing double voices.
Oh, 1 moment.
Carry on.
So I've had it's about 3 years ago, a resident, which he said is a resident on Windsor Road. He sent us an email, and I explained to him that Windsor Road, unfortunately, is a path to from the train station to Paragon building, which is a building on the other side of A40, I believe. It's a student accommodation, a large student accommodation. And then Windsor Road is used, especially on the weekends, is used as a path from the train station, which operates weekends 24 hours until late into the night at least. That a lot of students, they take that path from their socials, when they're going out, they use that path. There's a Wetherspoon, as I said, on the corner of Windsor Road, which is about 30 meters from Windsor Road. That is one of the busiest venues in the area. and they are a large venue. They also, their customers, they always, well, some of them will always use Windsor Road as a path. And plus
Sorry,
we have
Mr. Paget, sorry to interrupt you. I just wanted to assure you that these residents do not reside on Windsor Road.
All right,
Okay.
don't. Yeah, okay, take them. Generally, don't interrupt when witnesses are.
Madam, we have a pizza shop which is open until 4 a.m. It's a very busy pizza brand, and they've got takeaway. I think they got takeaways from 2:30 in the morning, which is the time which you operate only 2 times a week, which is Fridays and Saturdays. There's a very busy pizza shop which is adjacent to that number 2 at number 4. We do have, just be reminded, we do have above our building, there is a residence. We refer to them as our neighbours. They live straight right above the premises, and they've been doing so since we acquired, obviously, the location, since we've been there. And there's never been a report from the people living right above the premises. There's never been a report from them, including current or previous tenants, that of any noise or any disturbance coming from the building. Now, I understand that there is this individual, but it's anonymous. It's not known to anybody. And then they feel that they feel like coming forward to provide their, as I said, I've engaged with one individual who's emailed us, and I've addressed the issues and the noise levels as they're emanating from the venue. We did take measures, and we put limiters in music or basically noise coming out of the premises, which was completely eliminated as soon as this came to our attention.
Thank you. So a question to Mr. Dowding. In your submission earlier on, you were talking about item 8 on the table, and you were kind of disputing whether that was the responsibility of the premises. But can I put to you that if the people who are involved in fighting outside the premises were drinking in the premises prior to that, it would appear to indicate that they were getting drunk in the premises. So that does seem to be, is that not relevant to the way in which the premises are managed?
It certainly is. I think the point that I was making more so, and I'd just invite you, you've got the references in my submissions. I say B123 to 136, B is a reference to the police bundle. The Chris report, if you have a look at it, the point I was making is that all of the people who were present accepted being at other venues that night, and it's not clear on what order they were in which venues, where they had been drinking first and last. And certainly there was no suggestion that there was a fight in the premises that then spilled outside. In fact, my understanding from the report is that the premises was closed when the fight occurred. And so the point that I was driving at is, whilst of course a premises has responsibility for the amount of alcohol which is being consumed at their premises, it's something that Councillor Nagpal addressed with Mr. Paget a moment ago. And you've heard that the premises does have policies in place in relation to that. And whilst of course there is therefore a responsibility on the premises in relation to those patrons, I was just inviting you to take care when you look at reports like this and not to treat them as sort of fact in relation to this is an occasion where the premises has done something wrong, because that simply is not clear at all on the face of the report when you read it. As I say, there's no indication as to when those patrons were drinking, where they were drinking. The only indication is that they had drunk at other premises and that the fight itself was occurring outside on the street where Stack Bar is based.
Okay, thank you. And I think final question for me is to Ms. Pryor. So broad question, what management changes have you made since taking over as DPS?
So I am currently training someone to become manager of the bar. We've also hired another staff member, so we've hired new staff recently. So that's the current things that I'm taking, the steps that I'm taking, that we're going to be having new management of the bar.
Okay, but have you, in terms of, have you instituted, have you instituted any changes in policy? Have you told the existing staff that they should do anything differently?
Well, I've sat and had meetings with them about, obviously, if people are inebriated.
Yeah, I can hear you.
I don't know if anyone can hear me. Oh,
Yeah,
can
no,
you hear me, yeah?
we can hear you. Yeah.
Okay. Yeah. So I've sat down with staff. We do have weekly meetings about policies and how we go forward. Also, if someone's extremely drunk, then we would offer them a glass of water, ask them if we can get them home, order them a taxi. And going forward, if there are any incidents, then we do need to go to the local police and so on to prevent any other incidents occurring.
Okay.
That's no further comment.
Okay, thank you. Thanks. Right. Okay. So if there's no further questions from the other members of the panel, we will move to summing up. So if I can invite Mr. Soleimani to briefly sum up.
Yes, thank you, Chair. I will respond to a couple of points that really need to be responded to, and then I will summarize our case as part of my summary. So to begin with regards to the investigation into the incident, you've heard that one victim is indeed providing a statement in support of prosecution, confirmed that the other victim supports the prosecution. The reason he can't provide his statement is that he doesn't have any memory of the event after being knocked out unconscious, so he doesn't have a statement to provide. Regarding the crime reports that have been provided, I'm not sure why it's presented as sort of gotcha moment that a number of these crime reports didn't result in investigation or weren't blamed on the PLH. As you'll have seen from police summary, we were clear when the PLH wasn't responsible, when it wasn't their fault, when the investigation didn't go anywhere. The fact is, if we come to this meeting and we present only the crime reports that we think are really negative, then the operator is going to say, well, you haven't presented a full picture. But then if we present a full picture, they say we provide too much and we have to do something. We tried to be fair and balanced by providing everything and explaining where things didn't result in investigation. And all the points that were made that various incidents didn't result in investigations are things we expressly stated in our written submissions ourselves. Reality is there are a number of crime reports that were serious, that didn't have explanations, things like the two Brazilian friends who were racially abused by the staff, things like Mr. Pacherche trying to break down the door, as his landlord explained, and tearing down notices. Let's see, with regard to the video, with regard to environmental health and the points raised there, I'd say a few things. Firstly, with abatement notices, we were told they complied with abatement notices, and that shows they're cooperative. But of course, you have to because it's a crime not to. Same with complying with a police investigation, which Mr. Pacherche kept bringing up. He says once he was contacted by police, he cooperated fully, of course, because they contacted him when they were initiating a criminal investigation. Let's see, you certainly can put weight on the video evidence provided by environmental health. What you can put weight on is the environmental health officer's professional assessment of that evidence. In the same way you could put weight on her professional assessment of what she's seen with her own eyes. You are entitled to listen to what she says and put weight on that, even if the video evidence hasn't been seen by you. We were also told that the explanation for for some of the nuisances the environmental health had pointed to, which was a substantial amount of nuisance and a lot of issues, was that the area is a thoroughfare for students. We don't really accept that explanation. Locals and local businesses who make these complaints know their area. They know it's a thoroughfare for students. They're not going to mindlessly look at a group of students and then just blame the bar. They know what they're talking about. We don't accept that explanation. With regards to condition 30, which the committee brought up, I mean, we really have trouble with the legalistic approach that the operator is taking to this. I mean, whether the assault happened just outside the premises, so whether or not that technically comes within the breadth of the scope of condition 30. I mean, the point Councillor Nagpal made, that he should have called police, that his conditions require him, or at least encourage him to call police in those situations, obviously applies. I mean, it is a violation of at least the spirit of that condition to not call police when something that serious happens, let alone a violation of common sense. And I'll come, yes, and this is a more general point, but we were finally directly asked what the explanation was for failing to call the emergency services, and we were told a couple of things. One was that Mr. Bajerjo said he wasn't aware of the extent of the injuries. We really struggle to accept that. The reality is he knocked 2 men out unconscious with sufficient force, with 1 punch to each of them, and left them on the floor unconscious. They were both very drunk at that point as well, so obviously vulnerable in that sense too. The idea that you could do that, look at that, and then say, I had no idea they were injured. I had no idea they were in any danger. I thought it'd be fine to leave them there. Ridiculous. It defies common sense. It shows a lack of understanding of basic health and safety that anyone who works in a bar should know, let alone any individual. We were told also they didn't call emergency services because he was worried about the safety of the people inside. If you're worried about the safety of your customers, what you do is you call police. I mean, that is the correct response. You call police to control the situation. He said he was worried they'd get back up and attack him or his customers, then call the police. If he was so worried, he should have done that. Instead, he just left. What seems to me is the more likely explanation of this is they just didn't care. He knocked these 2 people out, felt to himself he was justified in doing so, and then just left and didn't think he had a responsibility to them afterwards, even though they were his customers, even though they were the victims of his assault. Chair, ultimately, this hearing is all about trust. It's about a PLH who has broken our trust, who we cannot trust to be responsible for upholding the licensing objectives. Someone we can't trust to run a late night bar and to be involved in the management of such. He doesn't take care of his customers when they're seriously injured. He doesn't think to call the police. He doesn't show that basic respect for health and safety or law and order. It is unacceptable. As your legal advisor explained, the license holder has a responsibility to uphold the licensing objectives. That's their legal role, that's their duty. The idea that the DPS does everything, which was put to you, and PLH seems to have essentially no involvement, is completely wrong. It's his business, it's his license. The new DPS is his employee. He's the person operating it. Without revocation of this license, with him still being the PLH of this premises, he will still be entitled to work there as a manager, and he will, and he'll do so either in name or effect. And that is the point. I mean, the police have thought very carefully, how do we control the risk of this reckless and negligent person being in charge of a late night bar with vulnerable, drunk people in his care? How do we control that risk in a proportionate way? And the only answer we have is revocation, because that's the only way to get him away from this premises and to prevent it being under his management. There's no condition that could achieve that effect. No condition that could achieve that effect was put forward by the operator. Nothing was put forward that could control the risk other than a written warning and whatever conditions the committee thinks are appropriate. They want you to think this person will have nothing to do with the business, but there's just no basis for that. He hasn't even said he'll step away. He will be running this venue. He will be the PLH. He will be the person employing the DPS. And committee, you just have to confront that. You have to confront that question. Is this the right person to be a PLH of a late night bar in Ealing? Is this someone that can get the committee's seal of approval as someone who can be trusted to uphold the licensing objectives, which is the PLH's job? It's someone who doesn't even call emergency services when people are in serious danger. Obviously, he's not the right person for that seal of approval. So yes, the reality is, Chair, he doesn't deserve a stamp of approval from the committee, and for all those reasons, the police see revocation as the only option in this situation to uphold the licensing objectives and to protect the customers of this premises. Thank you.
Yes, thank you, Mr. Soleimani. And now we move to the final summing up by Mr. Dowding on behalf of the premises.
Thank you, Chair. I just want to reiterate at the outset that events did, whatever anyone says about them, none of us were there. Events did move very rapidly on the 19th of September. Mistakes may well have been made. You might well reach that conclusion. You might think that things could have been done slightly differently. For example, shouting to a member of staff to call the police at at an earlier moment, inviting emergency services to attend sooner. But none of us can properly decide what we would have done in that scenario without having been there ourselves. And Mr. Bajorge, if nothing else, has been very frank with you, very open with you about why he made the decisions that he made and the pressures that he was under. Now, as a result of those decisions, he has been required since the initial hearing not to attend the premises which he built from the ground up. He's been required to take a step back from that premises as a result of the mistakes and decisions that he made, and to locate somebody else to take the mantle. But I again just reiterate in relation to the 19th of September that Mr. Bajorge has already expressed the fact that it may well be, and I said this at the initial hearing, I said it again today, that he perhaps should have reacted differently or could have done things differently. But it's a very difficult situation, and I think everybody can accept at least that much reviewing the CCTV and looking at the CRIS reports that have been served since then. And again, I just invite you to take a common sense approach to this. Human beings are human beings. We all react in our own way in particular scenarios. And it will be for a different court to decide if it gets that far, whether what Mr. Bajorge did was reasonable and lawful in the circumstances. You're looking at a premises license here. There have been lots of references to different types of licenses. You're looking at what you do about a premises license, not what to do about a personal license or a DPS license anymore, because you've already made your decision in relation to that. It is whether or not the license that attaches to this particular premises ought to be revoked because of one aberration, one incident that has never occurred or nothing like it has occurred before. Nothing like it has occurred since. Insofar as the conditions are concerned, can I just mention one point arising from Mr. Soleimani's submissions? He says that we've taken a legalistic position to the conditions. That couldn't be further from the truth, and you've just heard me outline yet again, I think for the third time now, what Mr. Bajorge's position is in relation to contacting the police. You've heard him be very frank and upfront about that. The only reason we mention condition 30 and what it says, and something you've accepted the importance of because you have changed that condition as an interim step, we've only mentioned that condition because it is that condition which tells the staff what they need to do to comply with the license that you've given them. It says that in the event of a serious assault, they need to call the police. Now, it follows from that anything less than that is within the judgment and discretion of the members of the premises. And it's a matter for you whether that's right. If you don't think that's right, you can amend that condition, you can modify it and include a much wider array of offences. But as things currently stand, the licence that you have given this premises states that where a serious assault, not even a regular assault, occurs on the premises, that is when the threshold is met to call the police. Now, call it legalistic, call it what you like, but that is the law, that is the condition that you have given them. And they are not breaching any conditions of the licence by not contacting the police when something lower than that occurs. Indeed, you might think yourselves that given the low threshold for a common assault or a battery, a bit of pushing and shoving, that the police would be being inundated with calls if every SIA officer at every premises was required to call the police every time someone gave them a push on the shoulder, every time someone shouted in their face. However, we of course acknowledge that where a review has taken place of this nature, you might want to go further than the existing condition, which is a pretty standard condition on a licence. In the case of this premises, you might think, well, actually, for the time being, because an incident of this nature has occurred, we're going to extend that and we're going to require you to call the police even if a very minor incident occurs at the premises. And so that is the importance of condition 30. That is why we have made reference to it. And that is one of the steps which we would invite you to take as a measure in relation to this premises. Addressing another point raised by Mr. Soleimani again, the DPS, as has been made clear to you by your legal advisor, is the person responsible for day-to-day management. Obviously, and it should hardly need to be said, but obviously a personal licence holder, when they're engaging in licensable activities, has a duty to uphold the licensing objectives. That doesn't take Mr. Soleimani's point that he made an opening any further. That is just an obvious thing. If you have a personal license and you work at Stack Bar and then the next weekend you work in a different bar, while you're serving people drinks, you obviously have a responsibility to uphold the licensing objectives. What Mr. Soleimani appears to have missed is that if Mr. Pagerge is required not to work at the premises, is required by you not to engage in licensable activities, then he will not be using his personal license. The DPS will be responsible for managing that premises, for ensuring that it upholds its licensing objectives. And more than that, you've just heard from Ms. Pryor that there is a new manager being installed to take over other management responsibilities, and new members of staff, all of whom, if they wanted to, could apply for a personal license. So it is simply incorrect to jump to the conclusion that because one person has a personal license, which you can't revoke because Parliament hasn't given you the power to do that, for you may think obvious reasons, that you must therefore jump above all of the other modifications that you can take to a license, all of the other powers Parliament has given you to modify conditions, remove DPS, suspend a license, etc., issue warnings, all the way to revocation over a single incident. That is simply not the case, and Parliament wouldn't have given you that suite, that repertoire of other powers, if they didn't want you to use them. Here, the obvious step where an incident has occurred involving one member of staff is the removal, the extrication of that member of staff from the premises and their replacement with someone more suited to deal with the premises moving forward. That is what has taken place. Another obvious step that Parliament has allowed you to do, add conditions to the licence, tighten them up, because breaching conditions can amount to a criminal offence. We would invite you to tighten those conditions up further in the ways that I've described. Informal action is another thing that the guidance urges you to do, issuing warnings. And undertakings by the premises are another area which you can explore. And I've said at the outset, and I'll say it again, the premises wants to work with the police and the licensing authority. Now, concerns have been raised or at least alluded to as to, for example, training and policies at the premises. We have invited you and would continue to invite you to urge the premises, indeed to urge the police to work with the premises to devise new training programmes to cover all eventualities, including any revisions made to condition 30, for example, requiring police to be called in relation to any incident that occurs at the premises. Those are the sorts of things that we would invite you to impose in addition to the measures that you've already put in place in relation to the premises. Unless I can assist further, I think that's all I want to say by way of closing. Thank you.
Okay, thank you, Mr. Dowding. Right, so now the panel will retire to deliberate together with our legal advisor and clerk. Should we try for 1:45? Sorry, Mr. Tipu?
Can I make a quick representation or sum up, or I'm not allowed to at this stage? And
dear, that's a question for Ms. Davis, I think. Does Mr. Tipu have an opportunity to sum up?
Chair, I would say no at this stage. You've heard technically Mr. Dowding and the premises licence holder are entitled to have the final word in response to the application that's being made.
Right. Okay. Yeah. Sorry about that. I mean, I think you did make your points, Mr. Tipu. Yeah.
That's fine. But I thought I was able to sum up, and then there was one point I would like to.
No, sorry. I think the general principle is that the premises have the last word on it. So I think we can't allow that, I'm afraid. Sorry about that.
It's what residents have asked me to put forward, but I thought I can do that in my sum up at the end. Okay. I'm
sorry. So no, we're going to retire to deliberate now with the legal advisor and clerk. Yeah, I think realistically, it's probably going to be 2 o'clock, I think, isn't it? By the time we can come back, I think, and then we will. Sorry, yes.
Sorry, Chair. Would 1:30 work? Because I've got other engagements.
How about 1:45? Does that work? I think 1:30 is going to be a bit of a push, isn't it? It's less than an hour. Yeah, so let's try for 1:45, shall we? To come back here, and then we'll explain the reasons for the panel decision briefly and give a full notice of decision afterwards. So, okay, if we try to reconvene at 1:45, thanks. So if everybody except the panel and clerk and legal advisor can leave the meeting, and we'll